moved out, you left the place clean. And weeks later, nothing. No deposit, no explanation. Maybe a check for $40 and a vague line that says cleaning fee. Here's what most tenants never realize. That money was never your landlord's to keep in the first place. It was yours, held in trust. And the law is far more specific and far more on your side than most people know. By the end of this video, you'll know exactly how to get it back. Let's start with the legal basics, because this is where landlords count on your confusion. Under statutes like Texas Property Code, Section 92.102, a security deposit is legally defined as an advance of money meant to secure your performance under the lease. Nothing more. It is not a slush fund. It is not free money the landlord gets to keep because they feel like it. And here's something most tenants don't know. The label on the money doesn't matter. Whether your landlord called it a pet deposit, a key deposit, or a redecorating fee, if it was collected to secure your performance as a tenant, it is legally a security deposit, and it's covered by the same rules. One exception worth knowing: monthly pet rent is a fee, not a deposit. But a one-time upfront pet deposit is your money, and it has to be returned the same way. In cities like New York and Chicago, there's also a hard cap on how much a landlord can even collect. Under Chicago's residential landlord and tenant ordinance, and under New York law, landlords generally cannot charge more than 1 month's rent as a security deposit. So, before we even talk about getting your money back, know this: there were limits on what they could take from you to begin with. Here's the part that trips up most tenants. Landlords are not allowed to sit on your deposit indefinitely. Every state puts a hard deadline on when they have to either return it in full or send you a written, itemized explanation of every deduction. In Texas, it's 30 days, but the clock only starts once you've surrendered the unit and given your landlord a forwarding address in writing. In New York, it's just 14 days from the date you move out. In Washington state, landlords have 30 days from the day you vacate. In Chicago, it's 45 days to return the money, but only 30 days to send you the itemized statement. And in Wisconsin, landlords have 21 days from surrender, which is either your lease end date or the start of a new tenancy if you left early. Notice something in Texas and Washington. If you never sent your forwarding address in writing, you may be handing your landlord a built-in excuse for being late. So step 1, always put your new address in writing and keep proof you sent it. One more Wisconsin note: some local ordinances used to require landlords to pay interest on your deposit while they held it. That's no longer the case under current state law, so don't count on that as leverage. This is the single biggest area landlords exploit, charging you for the normal aging of their own building. Legally, there's a firm line between normal wear and tear, which the landlord has to eat, and actual damage, which you're responsible for. Normal wear and tear includes things like faded paint, minor scuffs on the walls, small nail holes from hanging pictures, worn carpet in a hallway everyone walks through every day, and loose door handles from years of use. All of that is expected. None of it is legally deductible. Damage is different. Large holes from a mounted TV, pet stains, cigarette burns, broken window panes, mold caused by tenant neglect, unauthorized paint jobs. That's the kind of thing a landlord can legally charge for. And here's a trick worth knowing about specifically in Wisconsin and Chicago. Some leases include a clause requiring you to pay for routine carpet cleaning. Under Wisconsin's AT CP 134.06, a landlord can put that clause in the lease, but they cannot simply deduct it from your security deposit. If they want that money, they have to sue you separately for it. They don't get to take the easy route and just help themselves to your deposit. Now, here's why landlords should actually be scared of missing these deadlines. Because the penalties are not small. In Texas, a landlord who acts in bad faith owes you $100, plus 3 times the amount they wrongfully withheld, plus your attorney's fees. And there's a bigger consequence. A bad faith landlord in Texas forfeits their right to sue you for any damage to the unit at all. Under Chicago's RLTO, it's double the deposit amount, plus interest, plus attorney's fees. Though this specific rule doesn't apply to owner-occupied buildings with 6 units or fewer. In Washington, failing to return your deposit or send an itemized statement within 30 days can make the landlord liable for double or even triple damages. In New York, a willful violation can lead to punitive damages up to twice the deposit amount. And here's the part that really shifts the power back to you. In states like Texas and Chicago, if a landlord simply misses the deadline, the law presumes they acted in bad faith. You don't have to prove they were being sneaky. They have to prove they had a legitimate excuse, not just a reason for the deduction, an actual excuse for being late, like a documented emergency. So if your deadline has already passed and your money is missing, here's exactly what to do. 3 steps. Step 1, send a demand letter, not a text, not an angry phone call, a formal letter sent by certified mail so there's a paper trail. It should cite the specific law, for example, Texas Property Code, Section 92.109, or Chicago RLTO, Section 5-12-080. Mention the bad faith presumption directly if the deadline has passed, and give a firm deadline of 5 to 14 days for the full return of your money before you move to court. Step 2. Gather your evidence. Move in and move out photos, especially of appliances, flooring, and walls. Any witness statements. Your signed check-in sheet, if you had one. And proof of exactly when you sent your forwarding address. That certified mail receipt matters. Step 3. If the letter gets ignored, file in small claims court. You file what's called a summons and complaint. Filing fees are typically under $100, often around $95. And if you're low income, many courts will waive that fee entirely. You do not need a lawyer for this. And if you win, courts often order the landlord to cover your filing costs and attorney's fees on top of the deposit itself. Last thing, because the best time to win this fight is actually before you ever move out, or even before you move in. Always send your forwarding address by certified mail the moment you vacate. This is the single action that starts the legal clock in states like Texas and Washington. Request a move-in inspection and complete a check-in sheet within your first week. If your landlord doesn't offer one, make your own. Time-stamped photos of every room, every fixture, every appliance. If you're in Wisconsin, read your lease for something called a non-standard rental provisions page. Landlords there are required to separately identify anything they intend to deduct for later. And in Wisconsin and Madison specifically, you actually have the right to request what the previous tenant was charged for, so the landlord can't bill 2 different tenants for the same repair. So, let's bring it together. Your security deposit is legally yours, no matter what they labeled it. Every state has a hard deadline to return it. There's a clear legal line between wear and tear and real damage. Missing the deadline can trigger serious penalties against the landlord, not you. And getting your money back usually takes nothing more than a certified letter and, if needed, a small claims filing you can do yourself. Know your deadlines, keep your paper trail, and don't let anyone convince you that fighting for your own money makes you difficult. This video is for educational purposes only and is not legal advice. Laws vary by state, county, and city. Always verify current statutes for your specific jurisdiction before relying on any figure or deadline. Consult a licensed attorney for advice on your specific situation. If this helped you, hit subscribe. Every week, we break down real legal situations in plain English. And drop your state in the comments. I might cover your state's specific deposit law in a future video. See you next week.